Hi, I'm attorney Eric Traben. In this video, we're going to talk a little bit about Miranda rights. Most people have some idea of what Miranda rights are, and that idea is usually informed from watching TV or movies. Many people are familiar with the expression from the police where they say, "You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford an attorney, one will be appointed for you at no charge." By and large, those rights do fairly accurately encapsulate what those Miranda rights and warnings are. The confusion for most people surrounds when the police are supposed to tell you those Miranda rights. A big misconception is that the police are supposed to read you your Miranda rights anytime you get arrested or anytime you're dealing with the police. Nothing could be further from the truth. The police are only required to inform you of your Miranda rights during what's called a custodial interrogation. A custodial interrogation requires two things. First, that a person is in the custody of the police or is otherwise not free to leave, and it requires that the person is being questioned or interrogated, or that the police are doing something to try to get that person to speak. Those two things are required. A person being arrested and taken into police custody does not automatically trigger the reading of your rights unless the police are trying to get you to answer questions. And so one of the biggest things that people often get concerned about is they'll say, "I was just arrested, but the police didn't read me my rights. Does that mean the case goes away?" Well, unfortunately, the answer is no. The failure to read one's Miranda rights does not automatically result in charges going away. If anything, the Miranda rights only apply to those custodial interrogations. So when a custodial interrogation occurs, if the police fail to read a person their rights during that custodial interrogation, then the defense has the ability to ask the judge to throw out those statements. Now, throwing out the statements that a defendant makes to the police can be a big help in working out a case, but it doesn't always mean that the case goes away. Just because you get a statement or even a confession thrown out, there might be other evidence that exists that the state can rely upon that will still be used to convict a person of a crime. Not all encounters with the police, however, are custodial. There are so many examples where the police might question a person or talk to someone and not have to read you your rights. For example, if a police officer is approached by a member of the public on the street, that person walked up to the police and they can just as easily walk away. In that situation, the police certainly don't have to read that person their rights just to talk to them. On the other hand, there are times where a police might approach a person on the street and talk to them, and they don't have to read their rights either because it's what's called a consensual encounter. The person, the member of the public, is consenting to the interaction with the police. For example, if a police officer is walking down the street and points to you and says, "Hey, can I talk to you for a second?" Technically, you are free to say, "No, you may not. I don't want to talk to you," and walk away. Now, here's where the devil is in the details. It depends what exactly the officer is saying or doing. Is there a show of authority? Were the comments made by the police officer treated basically as a command? There's a difference between a police officer saying, "Hey, can I talk to you for a second?" and, "Hey, you, I need to talk to you, come here." So focusing on the police officer's actions will help determine whether or not an encounter with the police is consensual or not. And that's the first step in determining whether or not a person's rights have to be read. So we look at it by saying, first, is the person in custody or are they free to leave? If the person is free to leave, it's non-custodial. On the other hand, if it is that the person is not free to leave, clearly they are now in the custody of the police. Once you've established that, you then say, are the police trying to question this person? Are they trying to get the person to say something? And if so, then we know that the police had the obligation to read Miranda rights. Now, all of these things are extremely complicated and can be very confusing for judges, attorneys, and certainly members of the public. So if you're charged with a crime and you're concerned about whether your Miranda rights were treated properly, whether the police violated your rights to be informed, having the right to remain silent, or having the right to an attorney, you may have remedies, but you should have an attorney carefully review all of the evidence in your case to determine whether or not there is any remedy for the state violating your rights if there was a violation about the Miranda rights. I hope this helps you understand not just what Miranda rights are, but also when the police are required to read them to you. Stay tuned. If you have any questions, you can always hit us up at our website, www.trabenlaw.com.